In 2019, Ottawa introduced Bill C-69, known as the Impact Assessment Act. After the bill was introduced, the province of Alberta launched a legal challenge to the bill, arguing that it infringed on provincial jurisdiction over resource projects within the province. That legal challenge came to a head last Friday when the Supreme Court of Canada, in a 5-2 decision, found that the law could only apply to projects on federal land or those receiving federal financing, and that the federal government was acting outside of its jurisdiction if it used the law more broadly. Well, joining us now to discuss the Supreme Court's ruling, its impact on resource development, and what the ruling means for the division of power between Ottawa and provincial governments is Alberta Premier Danielle Smith. Premier Smith, thank you very much for joining us on Forum Daily.
My pleasure.
So before we get to the ruling, I want to discuss some of the specifics of the bill because I think that that's important. It was dubbed by critics as the No More Pipelines bill. Why do you think Bill C-69 was deserving of that name, and what additional requirements or restrictions did the bill place on resource projects?
Yeah, I know that my predecessor called it the No More Pipelines bill. I called it the No More Build Anything, Anywhere bill because it was so clearly overreaching into provincial jurisdiction. I think we've become accustomed to seeing the federal government have processes that are just so difficult to navigate that companies give up. We saw that with the Energy East pipeline. We saw that with the Northern Gateway pipeline, which actually got all of its approvals and then got canceled. We saw that as well with Teck's Frontier Mine, a $20 billion oil sands project that just couldn't figure out a pathway to success. And so the federal government has created a huge amount of uncertainty. And where they really overreached is they began reaching into provincial jurisdiction. They were trying to tell provinces that they couldn't develop highways or power plants or any major industrial project if they declared it a federal interest. And that's where the court said, absolutely not. The Constitution matters, that cooperative federalism is how our country works, and the federal government has to stay in its lane. So I think it's a wide-reaching ruling. I think it will apply to all areas of provincial jurisdiction, and we intend to use it to make sure that we defend against federal intrusion on all fronts.
And I'm going back now 10 years or so. Some of those criticisms were echoed by the business community at the time with the Harper era impact assessment. What specifically are the differences here in terms of how we regulated these projects before the Trudeau government implemented this bill? What are the distinctions here in terms of how the landscape changed?
Well, I think the thing to understand is that the federal government essentially has the authority over projects that cross borders. So if they're building a pipeline that goes across the entire country or between Alberta and British Columbia, that becomes a federal process. Where they don't have the power is if I need to expand a pipeline between Calgary and Edmonton, or build a transmission line between Fort McMurray and Calgary, or build a SAGD project entirely within our province. That's where they were overreaching. Is that there are certain nationwide infrastructure projects that absolutely do fall into federal territory, but they presumed that anything they had an interest in, that they would be able to take over the regulatory process. And the court said, you can't do that. And rightly so. That's I think what really pushes them back in their own lane.
And there's been quite a bit of response in regards to the ruling. The Calgary Chamber of Commerce called this a game changer. What exactly does this mean for resource projects in the province of Alberta or anywhere else for that matter?
Well, I can tell you immediately what it means is that we're facing some instability in our power grid. We almost had 8 near failures in the last year. And part of the reason for that is we need to bring on more baseload power. But because of federal uncertainty, because they deigned to say that they were the ones responsible for approving power plants, we don't have enough baseload power coming on to be able to maintain stability as well as to continue to grow. So that gives us in our province clear authority to be able to develop those types of projects. In addition, anyone who has been concerned about a federal regulatory process around oil sands or any other large industrial project, we're saying we're open for business because now we know that we have the authority, if it's 100% within our borders, to make the determination on whether or not those projects go ahead, and it'll follow our environmental assessment process. There are still obviously projects that we're looking forward to and encouraging to get to the finish line. The Coastal GasLink project is for instance, to
Mhm.
facilitate more LNG export, and that is has been a federal-led process. Same with the Trans Mountain Pipeline, which is nearing completion. That has also been a federal-led process. So you see that there are still important ways in which the provinces and the federal government have to work together. That's what cooperative federalism is
Yeah.
about. The problem is the federal government hasn't been keen on cooperating. They've been keen
Don't
on
mean to
acting
interrupt you here.
unilaterally.
We do just quickly have to go to break. We'll be right back with Premier Smith. Premier Smith, before the commercial break, you mentioned that Alberta was open for business. I think one of the questions here in the market dynamics is, do you have any indication that from an investor side, investors were waiting on the sidelines to fund projects, waiting for this Supreme Court decision or at least some alteration or amendment to that process? Is there an indication in Alberta that that type of capital will now flow into the province and we will see an expansion of some of these projects?
All I can know is the amount of outflow that we've had, the amount of projects that have been canceled, the number of businesses, and I was just at a business roundtable last night, the number of businesses who said, yeah, we used to have a lot more operations in Canada, in Alberta in particular, but we moved them. That
Mhm.
to me is a measure of just how much damage the federal government has caused, is that they created so much uncertainty that businesses who had cross-border interests or international interests just reallocated capital elsewhere. And so now we have a fighting chance of being able to get some of that capital to return to Alberta. We have immense opportunity in our natural gas basin. We've got immense opportunity with our net zero bitumen projects that the
Mhm.
Pathways Group is putting forward. Net zero hydrogen project, net zero petrochemical project. We're very much in sync with the plan to reduce emissions. And now we have the ability to tell the world that we have the authority at the provincial level to approve those kinds of projects. And we're going to continue working on that.
You mentioned the fight. Both the natural resource minister and the environment minister have indicated that they'd like to bring forward amendments. Do we have any indication in regards to what those amendments may be?
Well, I guess we'll have to see. The amendments need to take out entire sections of the act that have been declared by the court to be unconstitutional.
Mhm.
They may still want to maintain some of the parameters that they have around federally funded projects on federal lands and international, but they can't pretend that this court decision didn't happen. They can't pretend that a few minor tweaks are going to resolve it. They have to accept that the court will not allow for them to invade constitutional boundaries. Our founders put constitutional responsibilities in different areas on purpose. And the court just affirmed that that matters. And any scheme that tries to do indirectly, which they cannot do directly, is going to be declared unconstitutional. And we simply won't stand for it. We're just not going to be in a position where they're going to think that they can do some minor tweaks, invade our jurisdiction, act unilaterally, create investor uncertainty, and then we are going to have to fight to get our constitutional rights back. No, we are going to be waiving that Supreme Court decision every chance we get and
Well,
working on true cooperative federalism so that they work with us to achieve joint goals.
and on that cooperative federalism note, obviously that's been something that you've championed as premier and before being premier. Do you think that this ruling fundamentally changes or solidifies the relationship between the provinces and the federal government?
All I can tell you is how I've acted. My very first conversation with the prime minister, I told him I wanted to work with him on a carbon neutrality target by 2050. I
Mhm.
told him that we would produce an emissions reduction plan to get there, which we did in April. I told him that we would do abatement curves. We would figure out what the milestones would be along the way using S&P. We've done that work. I told him I wanted to have a table where we put our deputy ministers together with theirs. We did that. So I'm behaving the way I think cooperative federalism is supposed to work. They are not. Stephen Guilbeault, the environment minister, keeps on announcing unilateral policies almost every other day. Methane emissions reductions, caps on oil and natural gas, caps on fertilizer, bans on the ability to sell in combustion engine vehicles, net
Mhm.
zero houses. I mean, like these, the clean electricity regs, they're the ones that are behaving in a way that is contrary to the Constitution. And I would hope that they would read the judgment and act differently towards the provinces. They're the ones who I think are not acting in the spirit of how our country is supposed to work. I'll continue being cooperative and just hoping that we have a partner at the federal level.
Uh, you may not be able to comment on this, but I have to ask because you've mentioned some major sticking points between your government and Ottawa. Are more legal challenges in the works on things like the emissions cap or any of these other policies that Ottawa is putting forward?
It depends. I mean, if we can come to some kind of cooperative agreement on how we move forward with reasonable emissions reduction targets, then no. If they act unilaterally, yes. And I think we've got the power of the Supreme Court behind us now.
Well, Premier Smith, it's been a pleasure having you on Forum Daily. Thank you very much for staying with us, and thank you very much for weighing in here on what has been a big decision with the Supreme Court.
My pleasure.
Stay locked in to Forum Daily News as we unpack the stories making headlines around the world after the break. Nima Rajan will be looking at the latest in U.S. and international news, so stay with us.